Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I want to talk about a topic that doesn't always get a lot of attention in divorce cases, and that is life insurance provisions in divorce agreements. It might sound like a small detail, but life insurance provisions can make a huge difference in protecting your family's financial future after divorce. When one spouse is ordered to pay child support or alimony, there's always the question of what happens if that person passes away before those payments are finished. And that's when life insurance comes in. It serves as a financial safety net, ensuring that the support continues for the children or former spouse, even if the person paying can no longer do so. So it's not about benefiting an ex, it's about protecting the financial security that a court order was meant to provide. So you might be wondering who carries the policy. In most cases, the spouse paying support is required to carry a life insurance policy. The other spouse, or sometimes a trust for the children, is usually named as the beneficiary of the insurance policy. But often the person receiving support is also required to maintain life insurance, as the other parent will become a sole provider for the children if the person receiving support were to pass away. Now, a good divorce agreement should clearly spell out a few key details about life insurance. First, the coverage amount. So usually it's enough to cover the total remaining support obligation. The agreement should state the duration of the life insurance obligation, so how long the policy must be kept in place, and that is often until the children are grown or the support obligation ends. It must include the beneficiary designation, so who receives the benefit if the payor passes away, and usually it's the other parent or a trust for the children. Proof of coverage language, so the recipient's spouse should be entitled to at least annual proof that the policy is active, and there should also be a notice provision if any changes are made to the policy so that the person who is supposed to receive the life insurance payout is notified automatically by the insurance company if there are any cancellations or lapses in coverage in the policy. Without these details, enforcing the life insurance provision later can be difficult. And unfortunately, I've seen cases where a spouse was supposed to keep a life insurance policy, but they didn't, and by the time anybody found out it was not in place, it was too late. That person had passed away. So that's why these provisions need to be specific and they need to be monitored. The agreement should make it clear who's responsible, how much coverage is required, and how it will be verified. Now, life insurance provisions are enforceable like any other part of a divorce judgment, where if one party fails to maintain the required coverage, the court can order them to reinstate it or even secure the obligation through their estate. But ideally, you don't want to get to that point. The best approach is to make sure the language in your divorce agreement is clear and complete from the start, and that you monitor the life insurance policy being in place. So if you're going through divorce or revisiting your agreement, make sure the issue of life insurance isn't overlooked. It's not about planning for the worst, it's about protecting what matters most and ensuring financial stability for your family. So those are the basics on life insurance provisions in divorce agreements in Connecticut. As usual, if you have any additional questions, you can contact our office, and if you're looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well.